Hello, everyone, and welcome back to the judicial process. Today is going to be the first in a two-part lecture on judges. So today we're going to look at federal judges and federal judgeships. And then the next class, we are going to look at state judges and state judgeships. So that being said, let's jump in. So the role of a judge. We've all seen them on TV, and we see them kind of acting in a very gruff, kind of angry capacity. And it's not to say that judges aren't angry, a lot of them are, but there's so much more to it. So actually, if we look at the role of a judge, we can actually trace it back over 2,000 years ago. Socrates described the traits required for a person to be a judge. Basically, Socrates said in order for somebody to be a judge, they has to have the ability to hear courteously, to answer wisely, to consider soberly, and to decide impartially. All right, so these were kind of the requirements that Socrates believed made up a good judge. Now, we look at modern day, the idea of to hear courteously sometimes happens, sometimes doesn't. It just depends on the judge. Most of them have a very short fuse. If you don't respect the court, you don't respect the rules of procedure, they will admonish you. They will ensure that you, moving forward, have the respect for the court that you should have. To answer wisely and to decide impartially and consider soberly, kind of all are impacted here. If nothing else, out of our judges, the most important thing that we want them to be able to do is to decide impartially. All right, so the idea is they don't have a favorite going in, they are a blank slate if they are hearing a case. We're going to talk about the different ways that a judge can hear a case. Either a bench trial where the judge hears the case, or a jury trial where the judge basically acts as an arbitrator or an arbiter to ensure that there is a fair trial. But we want this impartiality, right? And what we're going to see is, unfortunately, politics comes into play. My apologies. Unfortunately, politics comes into play quite a bit in the selection of judges. So this is true at the federal level, but it's more so what we see at the state level. So when we talk about state level and talk about state elections and election of judges, you're going to see that there are some problematic things when it comes to partisan analysis. So that being said, if we think about the court, and this is usually how we refer to judges, as we refer to them as the court. So they can act in really three capacities. So they can be the umpire, they can be the adjudicator, or they can be a problem solver. So an umpire is basically when the judge is a neutral arbiter during a trial. Right, so this is a jury trial, usually, and the judge is just there to ensure that the rules of evidence and the rules of procedure are followed, to make rulings on objections in a neutral, fair manner, to ensure that the parties receive a fair trial. All right, so the umpire is really concerned with fairness. Then we have the court can act as an adjudicator. Right? In this role, the role of the umpire gives way to the realities of an overburdened system in which judges seek to achieve finality through expeditious case resolutions. Right, so as an adjudicator, the judge is the one making the decision, right, as to liability, as to criminal guilt, as to sentencing, what have you. This is where the judge comes into play. Now, ideally, again, if we go back to Socrates, you would have wise, sober, and impartial consideration. But in reality, when trials do occur, a large percentage of them are bench trials, and the judge, even in non-bench trials, really just throughout the whole system, the judge tries to expedite cases as much as possible. And the reality is the system in the United States is overburdened, overwhelmed. Contrary to popular belief, we are not a overly litigious society, so we don't engage in litigation that often. Most issues don't result in litigation. So you can imagine if things resulted in litigation the way we say they do, just how bad the system would be based upon just a small percentage of cases that become cases that have overburdened the system as it is, right? So depending on where you're at, it can take 1 to 3 years for a case to go to trial. And as the adjudicator, the judge is trying to speed things up so that they can get the next case and the next case, because they realize that the more time they spend on this case, the less time they have to spend on other cases, or the longer the parties will be waiting for justice, the bigger the backlog, the bigger the issue becomes. So again, they serve as an adjudicator. We want them to be fair. We want them to be impartial. We want them to be sober. We want them to be wise. But we also understand that there are certain realities of the American justice, if you want to call it justice system, that we have to deal with, right? And the other role that a judge can fulfill is that of the problem solver, right? So in this case, the judge is interested in the litigant's welfare. So often making inquiries of the litigant in a slow but meticulous manner. So this is, the judge is concerned about the parties and sees if they can resolve the issues between the parties, right? Without maybe necessarily having to go to trial, and kind of an informal way of checking in and making sure that everyone is okay, that maybe there's a way we can reach a resolution to this problem without having to go to a full trial. There's a great case. I show a picture in one of my other courses of this case, but there was a divorce case before a judge, and this would be state court, but for our purposes, it doesn't matter. There's a divorce case before a judge, and it had lasted, years. Like, the thing had gone on forever. And what the parties could not agree on, so they agreed upon everything, right? They agreed upon children, they agreed upon pets, they agreed upon everything. The only thing they could not agree upon was their, wait for it, collection of Beanie Babies. Yeah, so those of you who don't remember, Beanie Babies are like little stuffed animals. So they could not agree on, they had this massive collection of Beanie Babies of who would get the Beanie Babies. And the case went on, like a divorce case went on for like 3 years. Like an average divorce case, if it's uncontested, it will go on for maybe a couple months, that's it, with just like 2 hearings and that being it. If it's contested, it'll be a little different. But this thing lasted a ridiculous amount of time. And it got to the point the judge got so frustrated with the parties that he kind of went from being the adjudicator to a problem solver. So he ordered that all of the Beanie Babies be brought into the courtroom and dumped into a pile on the floor in front of the 2 parties. He then got off the bench, took a quarter out of his pocket, asked one of them to call heads or tails, flipped the quarter, and then based upon how the quarter came down, he said, you know, if you got the right side, you went first, and then the other side would go, right? So basically it was just, you're gonna pick out which Beanie Babies you want, we're gonna be done with this, so I'm gonna do this in a way where we don't have a trial, we don't have all this other crap. I'm gonna flip a quarter, and the person who gets to go first can get first choice, and then the other person gets to choose, and then the first person gets to choose, and then the other person gets to choose, and back and forth until you have figured out which Beanie Babies you want. And there's some great pictures of this, because you have the lawyers kind of standing there like, I don't know if the judge can do this, but in the courtroom, the judge is basically God, so the judge can do virtually anything they want. And it actually resulted in a resolution of the case. Ultimately, the parties came to a resolution. They divided the Beanie Babies. Obviously, they went for the most expensive or the most valuable ones first, then worked their way down. Some of the Beanie Babies were like a little tiny stuffed animal was worth like up to $10,000. It was absolutely insane. So, they had financial interests at stake, obviously, but it was over something so stupid. The judge said, you know what, we're just going to solve this problem, right? I care about your welfare. This is ridiculous. You shouldn't be on my docket. Like, you just need to be done. And so the judge made a decision and the parties didn't object, so it stood. Ultimately, the judge was the problem solver and came up with a good solution. What we're starting to see today is not only is the judge acting as an umpire, again, most cases don't go to trial. The adjudicator of the cases go to trial, a bunch are bench trials, so there is that decision-making capacity. But we're seeing more and more judges take on this problem solver approach and really solving cases in equity. And what that means is making sure that the parties are treated fairly, that they get a fair outcome. That's what equity means. It's just is essentially the parties believe that there is an equal treatment, right? So it doesn't necessarily mean they have to have an equal result, but as long as they are treated equally, and in such a way that we are trying to divert cases out of the system, stop cases from going to adjudication, clogging up the system, etc. In fact, a lot of jurisdictions, and this is true in the state of New York, this actually started with a district court in California. District court in California started making parties to a civil lawsuit. Usually these are big corporations suing each other. They had to go to alternative dispute resolution. So they had to go to a mediator, right? And they could not come to court, they could not have a trial, and they could not litigate until the mediator issued a certificate saying that the parties came and they couldn't reach a conclusion. And a lot of times the parties just sat there and stared at each other, right? Because they were just like, we're here to get the certificate so we can litigate. But it did resolve some issues. And New York State has taken this a step further. So New York State, we are starting to adopt a system of what's called presumptive mediation. What that means is in small claims court, in a lot of domestic relations cases, especially when it comes to parenting plans or custody decisions, they are automatically sent to mediation. Right, so that's what I do. Right? One of my jobs is I'm a mediator for the state of New York, and I'm an arbitrator for the state of New York. And the idea is there's so many of these cases, and again, if people are arguing over $100, why take up the court's time, right? Why waste it when the court can hear more serious issues? So they come to me, I mediate, basically let the parties talk it out, support them in their decisions, and let them come to a solution they can live with. And the thing I always tell them is, you all want to come to the solution. You do not want a court coming to the solution for you, because you will not be happy with what the court, no matter what the court says, you're not going to be happy, neither party. This way, it lets them come to their own resolution, comes to their own way to solve the problem, and releases some of the burden on the courts. And most of the time we do. All we have to do is send basically a sheet back to the court that says the parties have agreed to X, Y, and Z, and then the court blesses it, and the parties don't have to go to court again. It's over. We also do arbitration when it comes to lemon law cases. So a lemon law case is a vehicle that is really a piece of crap, right? We call them a lemon. So if you go to a car dealer, and in New York, the law varies, but let's say you go to a car dealer, and within the first 30 days of ownership, that car is in the shop for repairs because it had hidden defects or whatever. It's in the shop for like almost 50% of the time that you've owned it, or you've taken it to the shop 3 times or more, and then within like the first 100 days that you've owned it. There's very specific laws surrounding it. And what this happens is, if that's the case, under New York law, you can return the vehicle, the dealership has to accept it, and they have to give you a full refund of your purchase price of the vehicle. Now, obviously, dealers don't want to do this, so they contest it. Well, under New York law, they go to arbitration. So they come before me. And as an arbitrator, I act as basically a mini judge, right? So the parties put on their cases before me. Usually they don't have lawyers, but they show me records and they show me all this other stuff, and they make oral arguments as to like why it's a lemon or why it's not a lemon. And then it's ultimately up to me whether I decide that, yes, the car is indeed a lemon, and therefore the person they're entitled to their full purchase price back, or no, it's not. And if I say no, it's not, generally speaking, parties, either way, they can't appeal usually. But then you might talk about like a civil lawsuit. That's not saying I'm a lemon, but it's saying that you cost me all this money, you hid this from me, stuff like that. The big thing is when a car is deemed a lemon in the state of New York, from that moment on, it has to on its window sticker, right? So you go to a dealership, they have those window sticker fact sheets. It has to say that this car has been adjudicated to be a lemon. And so what that means for the dealer is not only do they have to return the purchase price of the vehicle, but they also eat the price of the vehicle, because nobody's going to buy a car that has been adjudicated to be completely defective, right? So they might try to sell it at a real cheap price. Usually they'll try to get scrap for it. But there is a lot of onus on the dealer to try and fight this case. And of course, the person who owns the vehicle is very frustrated and wants their money back, and just to go get a different car from somewhere else or whatever. A lot of times the parties will reach a resolution before I make a decision. So during their discussion, because they can ask each other questions, during their discussion, they often come to an agreement of, okay, we will pay for all the shop visits up until this date, and any further shop visits, you bring them to us, we will fix it for free for the next year and a half, 2 years, however long they decide. And if the parties agree to it, then I don't have to make a ruling, right? We just send a letter back to the court saying the parties have reached a resolution, and the court blesses it, and it's over. The parties don't have to go to court. So it's a really kind of interesting process where we're trying to take some of the adjudication responsibilities and the problem-solving responsibilities off of judges and put them onto otherwise non-appointed, non-elected citizens, such as myself. But again, we definitely see judges starting to become more and more of a problem solver just because of the backlog of cases in the justice system. So let's talk about Article 3, right? So we've talked about Article 3 courts. Remember, we talked about these are courts that were contemplated or made under Article 3 of the US Constitution. So these are federal courts. They are the district courts, the courts of appeal, the Supreme Court, etc. So as of 2020, there were 870 total Article 3 judgeships authorized by Congress. Of these, there were 860 permanent Article 3 judgeships and 10 temporary Article 3 judgeships. And so what this means is, as of 2020, there were about 900 Article 3 judges on the bench. So Article 3 judges, how they are selected is they are first nominated by the President of the United States. Now, the president often engages in a process if it's for like a district court judge, a trial court judge, even an appellate court judge for the most part, but usually it's just for district court judges. The president will recognize and has historically recognized what's called senatorial courtesy. And basically what the president does is listens to the senator from that state, right? So let's say that There's an Article 3 judgeship that opens up in Wyoming. The president is first going to ask the opinion of the senators from Wyoming as to who the judge should be. Right, because at the trial level, there's not really that much at stake. I mean, it's the appellate level and the Supreme Court where things are really, 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 really important. So they'll ask who they think it should be, and if it's in line with what they think is right, then they'll defer to the senators, and appoint that person. There are some instances where they won't, where they will listen to them, but then say, I don't agree with that, and appoint their own person. So senatorial courtesy is not required. It's just legitimately, it's just a courtesy. We'll ask the senators from that state first what they think, and then the president makes an appointment. So they're nominated by the president, right? Again, noting senatorial courtesy, and they are then presented to the Senate for the Senate's advice and consent. Now, every judge will go through a hearing, and we'll talk about that in a second, or a prospective judge will go through a hearing, even if they're trial court judges. Because you remember, these guys are appointed, and girls and gals, they're appointed for life, right? So it's not like they can just be fired. It's a big deal. So we engage in a very extreme process of vetting. So normally when somebody is nominated to be, or is on the short list to be nominated as a judge, they are vetted by the FBI. So this isn't just the FBI does a criminal background check. The district court judge that taught my federal criminal procedure class, he was a federal district judge from Puerto Rico, and he talked about his vetting process. He said they actually talked to his first and third grade teachers as to what kind of person he was in first and third grade, what kind of student he was. I mean, stuff that just doesn't seem relevant. Like, I don't remember first or third grade. Like, I have no clue. But the FBI wanted to know, and they talked to his neighbors. They wanted to see what kind of neighbor he was, if the neighbors had any complaints about him. They talked to, obviously, former employers. They talked to friends. They talked to family. They conduct a very thorough investigation. I mean, it is really, really, really intense. And this was just at the trial court level. So you can imagine where you have the appellate court or the Supreme Court, where things are like very big, right? Where their decisions are very big, their decisions are very important, what the result can be. So if we're doing this kind of vetting at the trial court level, the appellate and Supreme Court, the vetting is just unbelievable, right? Because the goal of the FBI is, if there is any piece of dirt, like if you were rude to a waiter one time, they're going to find out. And generally speaking, they're going to report it back to the president and to the Senate Judiciary Committee. Now, let's say this guy, I don't know, I don't know why he would be nominated, but let's say a guy is nominated who has a history of domestic violence, who's been arrested for domestic violence several times, who never tips his waiters, who people say is like a sociopath, whatever. That doesn't mean that the person can't become a judge, right? The president can always withdraw their nomination, and the Senate can always say no. But if the FBI presents all this information and the president's like, no, I stand by them, and the Senate's like, yeah, it's not a big deal, even though it's a huge deal, they can still become a judge. So just because the FBI finds dirt on somebody doesn't mean it's going to stop them from becoming a judge. So what's going to happen is the FBI is going to prepare this report, the president makes this nomination, and then a hearing is held before the Senate Judiciary Committee. In this, during this time, the senators who sit in the Senate Judiciary Committee are able to question the nominee about anything related to the job. So they might ask questions about, if you had this kind of case, how would you rule? You did this in the past, can you talk more about it? Again, at the trial court level, they're not overly, that's usually not televised. It's not usually like that big of a deal because there's almost 900 of them. But when we talk about the appellate court and especially the Supreme Court, that's when things get very serious, right? That's when you have the Senate Judiciary Committee will grill people, will just try their best to make a point, and they're trying to make a point to the other side that this person should be or should not be appointed to the court. So regardless of whether it is a Supreme Court justice or it's a trial court district judge, the Senate Rule 30 applies. And so what Senate Rule 30 states is, on the final question, to advise and consent to the ratification in the form agreed to, the concurrence of 2/3 of the senators present shall be necessary to determine it in the affirmative. And so what this basically means is the Senate Judiciary Committee, after their hearing, they are going to make a recommendation to the full Senate. The recommendation will either say confirm or not confirm, whatever. They'll make it to the full Senate. The full Senate follows Rule 30, and Rule 30 says that 2/3 of senators have to approve of the appointment. Right? So 2/3 of the senators have to say, yes, we agree that you should be able to, this person should be a judge, or no, and if it's below 2/3, then the person doesn't become a judge. Now the president can renominate, but usually they nominate somebody else. So again, it's a very interesting process. But even for trial court judges or Supreme Court judges, 2/3 of the Senate has to vote in the affirmative. So let's look at authorized judgeships as of December 2020. And this actually comes from the US courts themselves. So these are authorized judgeships. So they were at the United States Court of Appeals. There were 179. The United States Court of International Trade, there are 9 judges. United States District Courts, there are 673. So 633 permanent and 10 temporary. And the United States Supreme Court, there are 9 justices. So that gives us a total of 870. Again, almost 900 Article III judges appointed for life, as long as they don't misbehave or they aren't very obviously incompetent. They get to stay on the bench for as long, to a certain point. And we'll talk about that here in a second. So let's look at judicial compensation. So when you think of like an Article III judge, you think they're going to get paid a lot of money. And when you first see their salaries, it seems like they get paid a ridiculous amount of money. But not when you consider how much they work, that they probably have come from very large law firms where they're a partner. So they're used to making millions of dollars a year. And now they get reduced down to $205,000. I mean, I would take $205,000. I would not complain. I would be very, very, very happy. And most of them are, but it is kind of a power and prestige thing that they will take a big hit to their salary to engage in this Article III judgeship. So District Court, $205,000. U.S. Court of Appeals, which just always seems just so odd to me. It's just a little bit more. It's only $12,000 more. It's $217,000. Associate Justices of the U.S. Supreme Court, $251,000. The Chief Justice of the United States Supreme Court, $263,000. Right, so the top judicial officer in the United States federal system only makes $263,000 a year, right? And so, I mean, there's a lot of reasons and rationale behind it, but again, it's one of those things where if you get to be on the Supreme Court, yeah, you may make $10 million a year as a partner in your firm. But you get to be on the U.S. Supreme Court, you will go down in history. You will be remembered. You are important. And so people will gladly give up millions of dollars to make what they would consider pocket change, which maybe you and I would not consider pocket change. Maybe you and I think, wow, that's a great salary. But when you think about all the work they do and at the level they do it and what it means for the country, it actually is a relatively low number. So Article III judges, as I said before, they have life tenure. Now that being said, they may retire with full benefits. And when I say full benefits, this includes their full salary for the rest of their life. So they can retire with full benefits. They can retire and they get their full salary for the rest of their life, beginning at age 65, presuming that they have met what's called the Rule of 80. So the Rule of 80 requires that you have been on the bench for a minimum of 15 years. Right? So if you were on the bench and you got appointed when you were 50, at 65, you can retire with full benefits for the rest of your life. If you were 51, you can go to age 66, right? And you can see basically what we do is we add the age plus the years of service required up to 70. So when you hit 70, you only have to be on the bench for 10 years. So it means you only had to be 60 when you were appointed to retire with full benefits. Now, that being said, most judges who are eligible to retire do decide to continue hearing cases either on a full-time or part-time basis, and they are known as senior judges. Senior judges basically provide volunteer service to the courts, right? And if we take a look at the courts, they generally provide about 15%, and they deal with 15% of the workload, right? So it's an interesting case because they're just like, I retired, I get my full salary, but I'm still going to hear cases. Like, how can you be retired and still hear cases? They're not getting paid extra to hear the cases, right? So they are legitimately volunteering to hear the cases. And so you have volunteers that hear 15% of federal cases in court. Like, that's a really big deal. Like, when you take a step back and you think about it, the volunteer is hearing your case. But they're called senior judges, and generally speaking, they have the same powers as a fully active judge. That being said, because of their senior status and the lifetime eligibility, the demographics of the court have been slow to diversify. So if you take a look at box 2.6.4 of your book, it's on page 205, it looks at the demographics of Article 3 judges by gender and race. And what we're going to see is, generally speaking, up until we hit really the 1960s, 1970s, most judges, I mean, there's very few of them, Article 3 judges, but they're all male, right? And then as we progress, we see more and more female judges joining the bench and becoming Article 3 judges. So while demographically we skew male, white, these demographics are starting to change. Again, if we look at today, most people on the bench are white. There are a considerable number of African Americans, there's a considerable number of Hispanics, but they are still disproportionately not represented at the level that they should be, right? So if Hispanic people make up 20% of society, you would expect that 20% of judges, people on the bench, would be of Hispanic origin as well. And the idea there is just everyone's represented, it's a fair process, et cetera, et cetera. Okay, so let's move down from Article 3 to Article 1, right? So these are judges that don't get lifetime tenure. Right? What happens with Article 1 judges, right? And usually they're called magistrates. Magistrates are appointed for a 6-year renewable term. And they're appointed by the judges of the district court under a process that requires the judges of the district court to publish a public notice of the vacancy for the magistrate, from which people can apply, right? Anyone can apply. And what happens is there's a screening of the candidates by a merit selection panel of lawyers and citizens. right? And so what they do is they look at all the people who have applied to be the magistrate, and they make a recommendation to the judges of the district court as to who this person should be, or maybe narrow it down to like 3 choices as to who this person should be. Now, usually the district court judges have somebody in mind, and most of the time, like it's a fairly smooth process. That person will get appointed. That being said, there are some problems. There are some minimum requirements to become a magistrate judge. Right? So they have to be a member in good standing of the bar of the highest court of a state for at least 5 years. So that means they have to be basically a lawyer that has been barred in a court for 5 years. The second one is a little controversial. In order to be a magistrate, you have to be under the age of 70 at the time of your initial appointment. Right, so this is not related in any way to district's Article 3 judges and their rule of 80. Magistrates, you have to be under the age of 70 at your initial appointment. Now, you can be appointed several times in a row. It's 8-year renewable terms. Your subsequent appointment, if you're 72, that's fine. Right? It's your initial appointment, you have to be under the age of 70. And the idea is that you have the stamina to deal with the caseload, right? Because you're dealing with a lot of cases. Remember when we looked at magistrate courts, we saw that they dealt with a lot. And so it's like you have to have the stamina. You also have to have, and we look at this kind of separately, but it's related, the competency to perform the duties of the office, and you have to be of good moral character. You also have to be emotionally stable and mature. Right? And this is just a partial list of what the requirements are to be a magistrate. Well, now you see we have problems here with potential age discrimination. Emotionally stable, how do you define that? Because people have mental health issues, right? If somebody has depression, are they mentally stable? Are they emotionally stable enough to do the job? Maybe they are, right? How do you define a lot of these issues, right? So there's disability issues that come up in magistrate appointments. But like I said, generally speaking, it's a smooth process, even though there are what I personally consider big issues regarding age discrimination, discrimination of people with disabilities, etc. Like I said, generally it's a smooth process. The district court judges know who they want, and they get who they want. Now, let's talk about the jurisdiction that is delegated to magistrates, right? So magistrates can only hear cases, and we've talked about this a little bit before, that are delegated to them from the district court under either statute, so Congress has said that they can do this, local rules, so the district court has decided that as a matter of their rules, that certain cases will be heard by magistrates and certain cases will be heard by district courts, and or court orders, right? So a court just says, this is how it's going to be in the future. To this end, the duties of a magistrate judge may vary depending on the district court and what kind of delegation of authority that they have made. But the duties of magistrate judge really are defined and divided into 4 broad categories, right? And we've covered this before. So they can hear initial proceedings in all criminal cases, including felonies. They can hear criminal misdemeanors, the full case. They cannot make final judgments or hear or have trials for criminal felonies. Those have to go to the district court. They can hear pretrial matters and other proceedings in civil and criminal cases, right? So again, anything really pretrial they can deal with. And they can hear trials and they can hear civil cases, but only if both parties consent and say they agree to let the magistrate make the decision, which most cases they do. I mean, some cases they don't, but most cases they do. If the parties don't agree that the magistrate can hear their civil case, then their case gets passed up to the district court. Now, again, district court judges will be a little bit cranky about this. They shouldn't be, right? They're supposed to be impartial. They're supposed to be, very, kind of problem solving. They're supposed to be adjudicating in a fair manner. So they can't theoretically hold the decision not to have a case before a magistrate. They cannot hold that against the parties. Again, at least in theory. So if we want to talk about the workload of magistrate judges, so this was 2013, so it's a little bit old, but this is basically the type of cases disposed of by magistrate judges in 2013. So 2013, magistrate judges, not Article 3 judges, but magistrates disposed of. So they went to finality of 1,179,358 cases. And so majority of them are going to be preliminary proceedings in felony cases, right? So initial appearance, bail, etc. Followed by civil cases. Again, we're going to be dealing with pretty much pretrial matters and whatnot. Other additional duties in criminal cases, everything, again, that's not the hearing of the case itself, but maybe has to do with search warrants or something along those lines. And that's followed by hearing misdemeanors and petty offenses, which is followed by just kind of a miscellaneous category, followed by prisoner litigation, followed by only 15,804 civil cases on consent. Right, so again, most of what the magistrates will do does lend itself towards the criminal realm. However, there is still plenty of cases that they deal with at the civil level. So let's look at a couple of judges in particular, right? So we looked at a magistrate judge. They're an Article 1 judge. There's another type of Article 1 judge, and they're the bankruptcy judges. So bankruptcy judges are appointed for 14 years. Unlike magistrates who are appointed for 8, bankruptcy judges are appointed for 14, and they're appointed by the Court of Appeals for the circuit in which the district is located. Right, so they're appointed by the judges of the appellate court, unlike magistrates who are appointed by judges of the district court. Right, so the idea is they are looking for more general expertise in bankruptcy and bankruptcy law. So basically at its most basic level, judges hear arguments, the bankruptcy judges hear arguments on behalf of debtors, so people who owe money, and creditors, the people they owe money to determine the debtor's candidacy for bankruptcy relief. Right? Bankruptcy basically says we're wiping away your there's different ways you can file bankruptcy. You can either reorganize or you can file to have your debts discharged. And what it means is you get like a fresh start, right? You don't owe anybody any money. Generally speaking, you won't have much money to begin with. If you do, the judge is going to parse it out. But it does go on your credit report. Right? For 7 years, it'll show that you've declared bankruptcy. And that means you're not getting a loan, you are not getting a credit card, you are not getting anything for as long as that shows on your report. There's also different rules in place, like can they dismiss mortgages, or can they say you no longer owe money on your house, you own your house full out? They can't do that. They look at your vehicle, right? And if it's a brand new vehicle, they're going to tell you to sell it. They're going to order it to be sold by the trustee. So again, they are very much in equity, right? So they're trying to make sure that things are fair and equal, but understanding that people get themselves into situations that they can't get out of. Now, unfortunately, for I think all of us, student loans cannot, as of today, be discharged in bankruptcy. So that means you can't rack up a bunch of student loans and say, you know what, I don't have any money. I declare bankruptcy. I want those loans wiped away. That doesn't happen, right? Congress has made a special exception for student loans. And yes, it's because of lobbyists from the student loan companies, right? Because it includes not only private student loans or public student loans that the United States deals with, but also private student loans. right? So it's a very big problem. That being said, when we're talking about debtors and creditors, again, we're trying to hear arguments, we're trying to come up with an equitable solution. Most negotiations between the two are handled by what are called trustees, right? So the trustees are kind of like experts who try to make sure that, yes, this car is sold because it was brand new. Oh, it's their only vehicle? Well, there's an exception if it's your only vehicle. Or if it's over a certain number of years of age, you don't have to sell it, things like that. Like they do all the really fine details, ensuring that the creditors get as much money as they can while the debtor is still protected and has enough to basically restart their financial life. That being said, even though the trustees are the ones who kind of deal with most of the negotiations between debtors and creditors, ultimately, it's the bankruptcy judge who gets to make the determination as to basically as to whether and to what degree certain things are forgiven, certain things are not forgiven, what has to happen, what has to be sold, etc. It's ultimately up to the judges, but usually they're going to really rely on the trustees because the trustees are going to be just like experts galore in bankruptcy law. And again, their whole job is to make sure that things are handled fairly. But that being said, even though bankruptcy judges are appointed for 14 years by the U.S. Court of Appeals, they only, under statute, receive 72%, or excuse me, 92% of the salary of Article III district court judges. Then you have Article I judges on the Federal Court of Claims. So these judges actually, even though they are Article I, right? So they're not Article III, they don't serve for life. These judges are appointed by the president with, again, the advice and consent of the Senate. So there is a Senate judiciary hearing, all that still happens. So among the 16 judges that are on the Federal Court of Claims, the president designates one to serve as the chief judge. Right, so basically every incoming administration can say this person is now going to be the chief judge. They can change it to meet their agenda. They receive the exact same compensation as a district court judge. Right, so it kind of seems like already like they should be Article III judges, but they are not. And keep this in mind, Federal Court of Claims, they are not Article III because they do not have life tenure. Instead, they are appointed by the president with the advice and consent of the Senate for 15-year renewable terms. However, before the completion of a 15-year term, a judge may retire based on age or mental or physical disability. A judge may also be removed from office for incompetency, misconduct, neglect of duty, engaging in the practice of law, so basically they can't be lawyers while they're judges, and physical or mental disability. And they can be removed by the U.S. Court of Appeals for the federal circuit. So it's not up to the judge, it's not up to the president, it's not up to Congress, it's up to judges of the U.S. Court of Appeals for the federal circuit whether somebody should be removed because of one of these factors. Now, again, you do have an issue, especially when it comes to physical and mental disability. If somebody is in a coma and they're not coming out, they are brain dead, they probably are going to get removed from office, right? Even though they do have a disability and you think that they'd be protected under law, that it makes sense, right? If somebody gets in an accident and they're in a wheelchair, that Court of Appeals is not removing them from the bench. Again, because they can still do their job. And that's all we really want, is somebody who can do their job fairly, right? Who's competent, who is focused on their job. If something comes up, we usually give them it's kind of like a nice thing, the nice way out. So we can say, well, you can either retire or the U.S. Court of Appeals can remove you from office. And 99.99999% of the time, the judge is going to retire, right? Because being removed from office is literally being fired. So you can retire and nobody thinks anything of it. So there are some other Article 1 judges. So judges who sit on the U.S. Court of Appeals for the Veterans Claims, they are appointed for 15-year terms by the president with the advice and consent of the Senate. The court is authorized 7 permanent active judges and 2 additional judges as part of a temporary expansion provision currently in place. Now, judges have the option upon retirement to agree to be available for further service and to be recalled as senior judges. Right, so we are really mixing Article 1 and Article 3 here, right? Because Article 3 judges, when they retire, they can become senior judges. What we say, if you sit on the U.S. Court of Appeals for Veterans Claims, you can also become a senior judge when you retire. Now, during any period of recall of service, so we can make them come back or they can come back voluntarily, a senior judge has all of the judicial authority and powers of a judge in active service. Right, so there is a way that really that you could kind of, you're going to basically still be dealing with veterans issues, but theoretically you could be a senior judge in a district and serve in that capacity. We also have judges of the United States Court of Appeals for the Armed Forces, right? So this is different than veterans claims. This is armed forces. They're appointed by the president with the advice and consent of the Senate for 15 years. There is a restriction. Each judge must be appointed from civilian life, right? So even though they hear like criminal appeals from courts martial, or they hear other issues involving the armed forces, the judges have to have been out of the military for a certain period of time. They don't ever have to have been in the military, and it's actually preferable if they weren't in the military. But they have to be civilians. They cannot be people in the military. So you can't appoint a general to serve as, an active general to serve as a judge, right? There has to be usually they have to be retired, there has to be a big period of time, and then they are considered civilian enough to serve. But most of the time we're talking civilians, and really there's not that big of an issue. There's also 19 judges on the United States United States Tax Court, and they're appointed by the president, again, with the advice and consent of the Senate, and again, they are appointed for 15-year terms. There is no limitation about civilian life or anything along those lines, but usually we're going to hire people, the president is going to appoint people, and the Senate's going to approve people who are experts in their field, who practice tax law. It's not like you are going to be practicing divorce law and then you randomly get appointed to the U.S. Court of Tax, or the U.S. Tax Court. It's just not going to happen. So here's a summary of all the federal judgeships, right? So Chief Justice, Article 3, and it's a really nice little chart that gives you every Article 3 judge, who they're appointed by, their salary, how long they can serve on the bench. Then you get the Article 1 judges. Again, you get who they are appointed by, you get their salary, and you get to see how long their appointments are. And keep in mind, if you're Article 1, your appointments are renewable. So it's not like you have 8 years as a magistrate and then you're done. You can be appointed for another 8 years as long as you've done good work and you're not incompetent, you're doing your job. You'll generally just be reappointed because it's a lot easier. So that being said, next class, we are going to jump into the selection of state judges and look at see how they are selected. And you're going to see they are selected in a much different manner than federal judges. So that being said, as always, if you have any questions, comments, or concerns, please do not hesitate to reach out to me and I will get back to you. Thank you for watching, and I hope you have a great, great day.